Good morning. We are convening for a hearing in case number 19 CV 1301, Almanzar versus Kiwi et al. There are two motions that are docketed, I think, to be heard. Really, only one that I'm going to entertain argument on, and that is the motion for summary judgment by the plaintiff. The motion for extension of time to respond, I'm going to decide that based on the materials that have been presented. But I do want to address it. The comments, I'm not going to entertain argument, as I stated. I am profoundly disappointed that a party could ask for an extension, not receive the extension, and still file their response late. I mean, I can't fathom in what world anyone would think that's appropriate, because it's not. And I've looked at the law on this area, and it is debatable, I suppose, whether or not the court or any court must look at the failure to do something as to whether or not it caused any prejudice to the opposing side. I mean, arguably it didn't. I mean, I can't really find that a 2 or 3 day delay causes prejudice, but it is wholly unprofessional. I mean, you don't ask. I don't even think it is justified if you ask for permission. If you never ask for permission, and then you simply file it late. But I recognize people can make mistakes. But this wasn't a mistake. This was, we're not doing it. Not necessarily because of any desire to just be disobedient to what the court has said, that has ordered. But it wasn't an accident. I mean, when the time period came for the response to be filed, obviously the defendants knew that the time was running out. No notice was filed. No motion was filed at that time. No half-baked or written response was filed with a stated intention to supplement. Total silence, nothing. And then 2 or 3 days later, the response is filed, and there's no mention made at that time that it was even late, which was obviously known. I'm not going to put up with that again in this case. And it's not the first time that the defendants have done something like that. I don't know that I'm going to punish the parties for it, but if it happens again in any form or fashion, the defendant needs to expect that the attorneys are going to be sanctioned for it. If I thought I could report it to the bar of the state of Georgia that if it violated the rule, I would do that. And I'm going to review the rules of the bar to see if it does. But it is wholly unprofessional. It should not happen. I have to think back on my own career as a lawyer and what would I have done under the circumstances. I had a case one time where a party came to me and wanted me to file a slander suit, coincidentally one of the claims in this case. Thought he had a pretty good case, but time was running out. Slander has a very short window of the statute of limitations in Georgia. At that time it was a year, and it may still be a year, but that's what it was. And on the day before the anniversary of the slanderous statement, I knew it was a 1-year statute.
Posted the story, the plaintiff then, immediately started posting about on the plaintiff's social media account about,
So she thought the plaintiff was actually, at the time that she received this message, she really thought this was the plaintiff doing this?
Correct. I mean, she said yes.
And she thought the plaintiff was trying to set her up, so she'd just go ahead and take the bait and put it all out there.
Which her purpose was to show that the plaintiff was trying to set her up to so then the plaintiff could then go and claim that she posts fake stories.
Well, if there's a trial in this case, I hope she has a better story than that, because that makes no logical sense. I mean,
she probably be able to explain it better than I can, but that's the information that I have.
Well, there needs to be a serious evaluation of your case. If that's the defense that you're going to present to a jury, that she knew all along it was false, and she thought it was the plaintiff. She didn't believe it was true, but she went ahead and published it anyway. But when she thought the plaintiff was trying to set her up, no reasonable person would do that. I mean, that makes as much sense as nothing. I mean, so that's her source. Then if assuming that to be her source, she claims T.I. is the source for some things. Did she know who T.I. was?
No, Lovely T was never a source for anything.
Lovely T, is that it? It's not T.I., it's Lovely T?
Lovely T is the name of the blogger, yes, sir.
So Lovely T was not a source for any of these allegations?
No, what happened was Ms. Jones posted a video on her own Instagram account that went viral, that was about the plaintiff. That's when my client, the defendant, reached out to Ms. Jones for an interview. That's what whole that's how it was set up. During as she was talking to Lovely T, they used to be friends. Lovely T also has a YouTube channel. She also does the same thing. They post celebrity stories on their blogs, on their YouTube channels. She was talking. Lovely T is the one that I believe even told my client about the Jones video, the one that went viral from Jones's Instagram. When they were talking, Lovely T said that she might have had some receipts that show that some of the things that Ms. Jones was saying was not true, but she never produced or gave my client any of those things. My client.
Sorry, I got you. I was confusing Lovely T with being the source. Lovely T was the person who told her that some of these things might not be true. But I got you. Okay, I'm not really too interested in the stuff that Ms. Jones provided to her. At this point, I was more interested in the things that she said she had, or at least the plaintiff's attorney said that the defendant did not have a source for.
The source for some of the statements was obviously the things that Ms. Jones said to her in the interview, coupled with there are again numerous videos of the plaintiff herself on the internet talking about these herself.
Yeah, I think at one of our last conference that we had, I'm not sure what that might have been a motion to dismiss. Or the discovery dispute. That's probably what it was, that day-long hearing on discovery dispute. At least by then, I had made a statement that I questioned to some degree the plaintiff's claim for damages, given the profile that she has as a performer. Certainly, the videos, the music videos that she does, are very provocative. And that's probably a very mild way of describing them. Of course, a lot of that goes to damages, I suppose. But I guess you could argue that some of it may even support some of the allegations that the defendant made about her. Not all of them for sure, but maybe a few of them. But the more fundamental question I have for you, as it relates to these videos that you have, and I looked at your videos, how do you propose to make those admissible? To the extent that they are compilations, your client didn't, I'm presuming, didn't put them together, that she might have downloaded them from somewhere. It seems like the reasonable thing to have done would have been to have taken the plaintiff's deposition and show her the videos and ask her, is this her? Is this you performing or saying things or doing whatever? But you didn't do that. So how is it that you're going to get those admitted?
Well, the videos are, and again, no, my client did not put them together. It's the same situation with, it's the defendant, I'm sorry, not the defendant, the plaintiff, using her, Instagram Live or her Instagram profile and posting those videos where she just talks. They're not, music videos or videos of her perform. This is just like her, she gets on the live and she's just talking to her fans. Now, some of these videos that I'm referring to specifically as it relates to her making these statements that she was herself a prostitute. She refers to herself as a quote, and this I'm quoting, a stripper hoe, end quote, in these videos. She has had a huge social media following even prior to her actual, music career taking off. So she has had, her Instagram has been active for a long time, even before she, started becoming, an international celebrity. So some of these compilations are, it's people on YouTube, obviously, that put them together, but it's clearly her in the video. She has the same handle as she has now on her social media profile. So, we have not, again, this is the first time I'm hearing of those videos might have been doctored or, being edited. We certainly didn't edit them. We produced to the plaintiff as we, downloaded the video, as we found it on YouTube. They have not provided us with any videos, with the full videos from any of those clips. If they're saying that that the videos are doctored, then I would have expected to see, video, because their client is the one that posted those videos online. She's the original source of the videos. So whether someone else on
maybe that may be true. That's maybe logically true, but that doesn't necessarily mean it's true.
I don't know of any other way to get your own Instagram, an Instagram live video from your profile with your face on it to the internet, other than you being the person that posted or the user.
So I took a plea yesterday, and I've taken probably 20 pleas in the last year about people sending emails to companies and other companies sending millions of dollars to bank accounts based on these emails that look like, and for all appearance purposes, to the sender are the email addresses and bank accounts of the companies within there doing business, but they're not. They're spoofs, they're email scams, they're romance scams, all these things are occurring. It's not an admissible document simply, or video simply by saying McCall's. There's a procedure you can go through. And one of the ways was to take the plaintiff's deposition and show them to them and say, did you say these things? She may have said yes, she may have said no, but you didn't do that, so you don't have that today. Now, you submitted them to us, so I guess we can look at them, and I guess we're all familiar with what the plaintiff looks like generally. And so perhaps under the federal rules, I can surmise that, well, there is a way for you to make these videos, or at least parts of these videos, admissible at trial, because the plaintiff will be here, and you can ask her. And if the plaintiff wants to make a motion in limine that we have that discussion outside the presence of the jury, so that you can ask her about these videos before you try to move them into evidence, then I suppose that we can do that, or you can even make that motion, I suppose. But as far as I know, that's really about the only way you're going to be able to get them into evidence. It's not... You couldn't put a witness on the stand who says, I've looked at this video, and this video is the plaintiff. The law doesn't allow you to do that. The jury could do that, I suppose. But
my plan was to ask the plaintiff, to get them into the plaintiff, because they depict her, and presumably, they depict her to my knowledge and understanding. So that was the plan to how to authenticate them, because.
Okay. So let me ask you about the Pornhub video. Did your client admit that she knew that was not the plaintiff when she published it?
No, Your Honor. In fact, what she actually testified to her deposition was that somebody sent her a link to that video, to her DMs, and she reviewed it, and it looked.
She thought it was the plaintiff.
Correct. because it's in, the setting of the video is inside of a strip club, which the plaintiff used to work at a strip club, and it looks like the plaintiff. So that was.
So the plaintiff is presumably going to testify at trial that is not her, that she did not engage in anything of the sort as alleged. And so there's her testimony. And then your client certainly doesn't know, and in trying to defend herself, I guess you're going to ask the jury to take a look at the video to determine whether it was reasonable for your client to assume that was in fact her, so that she could then go report that she saw the plaintiff doing these things. Is that the way you anticipate this will work at trial?
That's what I was anticipating. Yes, John.
All right. Anything else you want to say about the legal claims the plaintiff has asserted themselves, the intentional infliction claim and the slander claim?
Yes, Your Honor. Just briefly, just wanted to touch upon a couple of things that Ms. Matz talked about in her argument.
Videos didn't say she had STD of any sort yet.
No, the videos that I'm referring to were mostly discussing the drug use and the prostitution and the stripping.
In that initial interview with Ms. Jones that kind of began all this, was there any discussion then about the whole thing with the beer bottle? Did that come after that?
No, that wasn't mentioned at all in that. To my recollection, that was not mentioned at all in that interview.
All right, so what you're saying then is, okay, so this lady, did she know, by the way, did your client, prior to seeing Ms. Jones' statements, whether they were in written form or video form, and prior to interviewing her, did your client know Ms. Jones? Have any information about her veracity about anything?
No, no.
And so your client took what Ms. Jones was telling her and what Ms. Jones was claiming, and then she was taking the public profile that your client was aware of and saying that was enough. And so they're going to publish this stuff that Ms. Jones is saying because I think I've got enough there. I mean, there's nothing I'm missing about what your client was relying on when all this first began. She started saying this kind of stuff.
The statements that plaintiff made herself out of her own mouth.
Well, I was including that in the public profile.
Oh,
so,
yes. Then yes.
So public profile plus Jones, and so that was enough for her.
Yeah, and to be clear, in the Jones video,
her being the defendant.
Yes. To be clear, in the Jones video, they what neither Ms. Jones nor my client, the defendant, ever said that the plaintiff had any STDs. What Ms. Jones said was that the plaintiff, had cold sores on her mouth during the time that she knew that they knew each other, or that, during that short time that they worked together at the strip club. So that's all that was said about it specifically. I believe, in fact, Ms. Jones specifically said that she did not. She was not talking about herpes of.
Did your client later refer to the plaintiff as herpes B?
She did, but
that becomes a statement of fact, doesn't it? If I referred to Judge Roy Moore in Alabama as child molester Moore, I mean, that would be implying that I gave credits to the allegations against him, or I could pick anybody, O.J. Simpson as Killer Simpson. I mean, when she called her herpes B, with B being part of her stage name, I mean, that's a statement of fact.
She also referred to her as cold sore B. Those were interchangeably referred to her as both And cold sores are obviously medically known as herpes. So that's really where that all came from.
Cold sores are what now?
Cold sores are herpes. Like the medical term for cold sore is herpes. So she has never said anything about the client. She's talked about plaintiff having basically cold sores. There's pictures that appear that the plaintiff does have cold sores on her mouth. And so like that's all that, that they were talking about. They were not discussing her.
You're going to have testimony in this case that that a cold sore must mean that you have herpes?
I mean, it's not. If you have cold sores, that's what they are. They're herpes.
Okay, I understand that herpes may manifest itself in cold sores. Are you saying that cold sores always mean that someone has herpes?
That was my understanding.
Okay. All right, I never heard that before. So you may be right, but I can just remember in middle school knowing people with cold sores and never knew they had herpes. I'm not sure that is right, but I'll take your word for it at least right now. So your defense then for the defendant on that is that when she said she called her herpes B, she wouldn't say anything that wasn't true.
Correct, Your Honor. Our defense is the truth, that these statements are true. That's basically the defense for the most part, yes.
Anything else, Tom?
Just one more thing. In regards to the intentional induced emotional distress, I believe Ms. Matz had mentioned that they had provided us psychiatric records, and I just wanted to mention, because we did discuss the same thing about, my client, the psychiatric records that we've received, they involve two summaries, typed out summaries, just like, the ones that we sent. The first summary was made on October 26, 2020, and it's titled Therapeutic Coaching Summary, and it relates back to a session that the plaintiff had with this, this coach, this therapist, or whoever this person is, back in 2018. So again, 2 years later, a summary is typed up. And then on December the 7th of 2020, we received a second summary that was called a psychological treatment summary that basically stated that the plaintiff followed up in November of 2020 on her November 2018 session with this therapist. So we don't have any records that were made at the time of the treatment of the plaintiff. So.
I'm sorry, why are we talking about the plaintiff?
Because I believe Ms. Matt said that to prove the IIED claim, the plaintiff's IIED claim, they had submitted the psychiatric records. So I was just wanting to let Your Honor know that